Lordship, I beg to
Yes, yes.
Lordship, I beg to ma-
Item number?
The petitioner has expired, Your Lordship.
Okay. Mm, This is submitted by you, Mr.
R. Karim on behalf of IH Lashkar.
R. Karim, appearing on behalf of IH Lashkar, Learned Counsel for the petitioner, submits that the petitioner has in the meantime expired and his legal heirs are not interested to pursue this criminal revision petition. In view of the aforesaid, the present criminal revision petition stands closed.
Obliged.
Just a minute, Mr. Chaudhuri, though it is your on the top of the list, I will take up this matter with item number 5. Just little bit, we'll clear these orders and bail matters. Yes, Mozumdar, we are not interested. Any urgency?
Waiting promotions, otherwise no other agencies.
Because in the midst of
salary,
this,
everything.
midst of all these criminal petitions, what not, it's not possible. December, we'll give a date on the prayer of Mr. Mozumdar.
Regular bench.
Huh?
Regular.
No, this is review. Okay. On the prayer of the Learned Counsel for the petitioner, matter stands adjourned and be listed. Give last chance on the 21st of December. 21st is a holiday? Then 28th of, we'll take a chance on it.
20th.
Huh.
But instead of at my request, could it be the consent of the parties?
With the
Both parties.
as agreed to by okay. As agreed to by the Learned Counsel for the parties, list this matter on such.
Material instructions.
Yes. Not only materials, partial things are very difficult.
Obliged.
Yes.
My lord, as regards item number 11 and 12, my lord, I have been, my lord, engaged only day before yesterday in item number 11. And in this case, my lord, there is another difficulty, my lord. The CBI counsel, Mr. Manav Saloi, he was earlier defending, my lord, one of the accused, Deepak Hazarika, my lord. So whether, my lord, he would be able to, my lord, appear for this.
But he is not here. Nowadays, earlier, okay, that your prayer is genuine, we'll adjourn it. But in earlier, Mr. Talukdar, B. Talukdar was appointed as MI. He is also not here.
My lord.
Now the situation has come to his position that now I think we'll have to appoint MICAS for defense also.
My lord. Not defense, for prosecution.
For prosecution. For the respondents in the state and CBI. We are thinking of that. We may engage somebody for CBI also. Let us, this is a stage of appeal.
For my lord, CBI, public prosecutor, whether some notification.
Now tell me, what will be, suppose CBI counsel is not present. What should we do? These are the matter of 2014. Either we'll call the Director General of CBI to be present here.
But they should appoint some, my lord.
Some, that because that was there. Okay. Mr. B.M. Chaudhuri, Learned Counsel, submits that he has been engaged in this case to argue yesterday only. Therefore, he'll require some time to go through the papers. Accordingly, matter stands adjourned and be listed. Listed when? Yes, CBI, when? You cannot appear. So what is your alternative
I
arrangement?
have already written to the department to engage. Lot of process is going on. Very soon they are going to apply.
Okay. Now when?
Month of December maybe.
Okay. 10th of December. Huh?
Italy.
Little late. Okay.
It is 24th of December.
24th will not come. If you come, we do not know. You can come. I will not come.
23rd is holiday.
In fact, we are thinking of it. If those judges available, let them take hearing matters during vacation. If you are agreeable, both parties are agreeable. It's not a bad proposal. I'll place it.
Huh? Let it be on then 19th.
19th.
Obliged.
Both.
May I please, Lordship?
Hmm.
Petitioner behind the bar as on debt loss of 1,016
What,
days.
what are the
This is
offenses?
Sarcidet letter offense under section 360 IPC reduced section 4 of.
360
360 of IPC Lordship,
363
66 Lordship.
366 and
And section 4 of the POSCO.
4 of POXO.
where is the statement, where is the evidence of the victim?
Lordship, that is page 25 Lordship. Out of 9 possible witness,
Why this matter is listed before this court?
was earlier rejected this one.
Page
Page 25 Lordship. Six already examined out of 9 possible. Also examined Lordship.
you are not to say comment anything, but you are a difficult person. If you are allowed, you may cut your hands once again.
Oh, Lordship, already.
He is already a married person, right? And 2 children. By
Any
suppressing that
condition,
fact.
Lordship? Already for 4 years above, he is behind.
How many witnesses listed?
Place Lordship, already 6 is already examined Lordship.
So this is the witness of PW1.
W is the informant Lordship.
What is the next date?
Uh,
What was the last date as per record?
Only 3 witness remaining. One is a medical officer, who
Hmm.
is IO Lordship.
Only 2.
So 3 witness remaining exam, and
Mhm.
7 is medical officer, and 8 and 9 is IO SI of this. That is
Medical
IO.
officer and investigating,
Investigation.
2 investigating
Two
officers.
investigation remain for examine. Of affairs Lordship. Already 4 years behind the bar Lordship. Finally, the length of any condition Lordship. Cooperate with the trial Lordship. He is also local person. Lordship.
Comment of notice then and
This is-
my lord, service report regarding informant is also awaited.
Awaited.
We have taken steps through OC Lordship on 15/10, and as per office note.
How you have taken the steps?
OC Lordship.
Through PP of office of the
Yes.
PPA, huh?
I can also get the
Okay.
instruction.
Mr. Borthakur, learned counsel for the learned additional public prosecutor submits that he may be granted a week's time to obtain the status report as regard service upon the respondent number 2
Yes.
through the concerned police station. Prayer is allowed. List this matter on
20 of 2011.
2011-2024. Please bring the present status.
Lordship.
The learned counsel for the petitioner shall also obtain the next date of the case before the trial court, trial judge, as well as instruction as regards whether any witnesses has in the meantime, any further examination of witnesses has been carried out in the meantime.
Much obliged. Continue.
May I please your lordship,
Mm.
sir? Vishnu dated 29/10/2024 says that no answer.
The present revision criminal appeal is preferred against judgment and conviction passed by learned special judge under section under section under section
7 of the PC Act. my lord.
huh?
7 of the PC Act.
7 of the PC Act. Full stop. In the aforesaid backdrop and as per extant norms, the informant is not a necessary party for this revision. Therefore, and accordingly, matter is ready as regards service. List this matter for already admitted. List this matter for hearing on a date to be fixed by registry. Five and one will take a little bit later. Just wait for something. Yes.
Lordship, we have compromised in this matter.
Compromise.
Yes.
It is submitted by the learned counsel for the parties that the parties have amicably settled the dispute between them. First up. Mr. Saranya, learned counsel submits that in view of such compromise, matter may be closed. Accordingly, the criminal petition stands closed. Interim order, if any, stands vacant.
My colleagues, he is doing the matter that washing matter, Lordship, compromise, Lordship, informant affidavit, that is not permissible. But perhaps I have, he talked with the client, Lordship, the victim is also now ready to, because now they are living peacefully.
You file an application, joint application. Pursuant to this court's order dated 7/11/2024, learned counsel for the petitioner submits that though compromise on behalf of a victim,
Informant.
compromise by an informant on behalf of a victim is not permissible. However, such compromise was entered by the informant being father of the victim, and in fact, victim had also consent for such compromise, and therefore they submit that they would like to file and they would like to implead the victim in the present petition as party respondent and would like to file an affidavit on behalf of the victim for further consideration. Full stop. In view of the accordingly, a prayer for adjournment is made. Prayer stands allowed. List this matter
After 3 weeks. Lordship.
after 3 weeks on a date to be fixed by registry. You do it.
Yes, yes.
See, it's not. You could have filed a joint petition.
Let me also.
The council of other side, Lordship.
So if it is permissible, we'll allow it. That's it. Yes, Rajaji, what should we do?
I'm bring the file, Lordship, after something.
Okay, but
That is conviction under section 23, 3 months, Lordship.
See, otherwise materials, the victim has remained constant. Now, husband is not an eyewitness. That is fine. But admittedly, I do not find any ground to interfere in a revision petition, except maybe probation of offender. That
Yes, Lordship, that was my last submission.
I do not find anything beyond that.
There was also Lordship story of the, in fact, I have just now I have perused the case diary also, Lordship, that statement, Lordship, that is very different from the.
But
she is improving.
nothing has been contradicted during trial. So
It's
how can
minor contradiction.
all these are minor contradictions?
Admittedly, there are some dispute prior to this between the victim and that PW3 eyewitness, Lordship.
So therefore,
Regarding
at
a room.
best, therefore, considering all these
Yes, that's why, Lordship.
probation of
Yes,
offender,
Lordship.
that's
In
all.
fact, that's in this stage also, Lordship can.
Yes, that is not no problem on this.
My last submission, Lordship.
I
will
think
be
you
this.
should stick to the last submission only.
That's
I do not think
yes, on merit, Lordship.
merit, and that too in a it is not an appeal,
This is revision.
revision. And both the court, in fact, appellate court has very nicely dealt with all the
In
things.
fact, I have checked the record, Lordship. Perhaps he was behind the bar for only 1 or 2 days, Lordship.
Mm.
Not more, Lordship.
We understand this is
If
their
you-
neighbors, who will consider their neighbors,
Yes.
okay?
Earlier
They are their neighbors, earlier there were disputes, so therefore,
now they are maintaining a coordinate relationship,
Yeah.
Lordship, and there is no past criminal record.
and
Lordship.
where is Mrs. Chakraborty? If he had been there, we could have also recorded. Okay, we'll say no, none appears to press their case.
Obliged, Lordship.
Okay, I will dictate this order. Hard. This is item number.
8.
So this will be my last item here and 2 other methods. And all 3 are same. 1, 5 and
8.
8. All are probation, nothing more than that. You are for legal aid. In which case?
Item number 5.
5, my lord.
Yeah, Lordship,
In your
provision-
case.
yes, provision was granted, Lordship. Against that, we have come. 384.
Probation was granted.
Without mentioning any reason, Lordship.
Ah,
That's matter, Lordship. Item number 5, Lordship.
My lord.
Then Chakraborty is here, man.
yes, Chakraborty.
Number 7, my lord. They have
Take your breath. Take your breath. Take your breath. Okay.
my lord, in
Item number 7, we have
Because the
that
query
we
that
have,
was-
we have adjourned.
Yes.
Now please come to item number 8.
item number 8, my lord, I am appearing for the informant.
So we are proposing to give benefit of probation of offenders.
Section 360.
Just give me a minute. Give that file, first one. 1 and 5. Hmm. Okay. This is item number 8. Third, MSP Bhattacharjee, Learned Counsel for the petitioner. You take a seat, we'll call you. Your item is 5. Just we'll come to 1 and 5 later. And Mr. Swanshu Sharma for the B. Sharma for the Learned Additional Public Prosecutor. Also heard Mr. Chakraborty for the informant.
Yes.
The present revision petition is filed assailing a judgment and order dated 9/3/2010 passed in GR case number 16 of 2009 by the Learned Chief Judicial Magistrate Golaghat, convicting the accused petitioner under section 341/342/325/354 IPC and sentence him there is no sentence, na? Only 500 fine.
Lordship, sentences, there are 354 3 months, Lordship, RI for
Okay.
3 months,
Sentence him to pay a fine of rupees 500. And
under
in
section 341.
sentence to him pay fine of rupees in default. Imprisonment of 15 days. And also RI for 1 year for offense under section 342.
Yes, 1 month, not 1 year, 1 month.
1 month. 1 month under section 342 IPC. In 351,
354 3 months.
and also RI for 3 months under section 354 IPC.
And RI for 1 year.
And RI for 1 year.
And fine of rupees 500.
And fine of rupees 500 under section 325 IPC. The further challenge is judgment and further challenge is appellate judgment passed in criminal appeal number 14/2010 dated 3/7/2013, whereby the Learned Session Judge Golaghat affirmed the judgment and sentence passed by the trial court.
Altered, Lordship, 320.
Judgments
Altered.
modified the judgment and sentence
Others are same only.
by maintaining the sentence under section 341 and 342 IPC, and the petitioners were acquitted for the charge under section 354 and 325, acquitted from the offences under section 354 IPC.
Yes.
And offense since offense under section 325 was altered to 323 and sentence was modified for imprisonment of 3 months
And fine of rupees
and
500.
fine of rupees 500. in 500, full stop. The prosecution case in nutshell is that on 4/1/2009 at around 4 p.m. the mother of the informant, that is the victim, namely Geeta Das, was assaulted by their neighbor, that is the petitioner herein, namely Ratul Bhuya, by means of a bamboo stick when her mother was on the way back home from paddy field, and a result, her mother had fractured her right hand. Full stop. To bring home the charges, the prosecution examined as many as 6 witnesses, including the medical officer and the IO. Full stop. The accused was examined under section 313 CRPC. Full stop. Examined Swenchu. In 330 statement, the accused has denied the incriminating evidence materials evidence against him and wished to adduce evidence and examine himself as DW1. Full stop. After appreciation of the evidences, the learned trial court has convicted the petitioner as recorded herein above. On appeal, the learned session judge reappreciated evidence in details and came to the conclusion as recorded herein above and modified the sentence. Full stop. The learned counsel feeling aggrieved by the aforesaid judgments, the present revision petition is preferred. MS Bhattasarji, learned counsel for the petitioner, confined her argument to the effect, has confined her argument to the effect that the accused appellants have not been convicted previously for any offense and he is a first time. Want to say something? Yes, yes. But we'll record that you have no objection. Okay. First time of any offense and he is the first time offender. She further submits that no, the patar agote likha, ei line to agot. The learned MSP Bhattacharya learned counsel at the outset submits that she is not challenging the impugned judgment and order of conviction on merit and is confining her submission in the appeal only with the respect of the order of sentence. It should be the same submission, Mr. Chaudhuri, in your case. So we are dictating a common judgment kind of a, so that first part will just dictate. All only facts will be different. So this will be, so please go through it so that this will be the final part and argument will also be same. Other case will be a little bit different. Okay.
Reverse.
Reverse. Ki kolo? Sentence. Then you write down as 02nd line hole that not convicted other. The learned counsel further contends that this that the accused and the petitioners are neighbors and the dispute arose out of a trivial issue, and there has been some previous litigation between these parties. Therefore, in the aforesaid backdrop, anything was dealt by the learned court below, whether
Cross also there is,
as regards whether it should be granted or not granted.
yes, the trial court lordship only stated that considering the nature of the offense,
full stop.
to have not been committed by the accused, the accused could not be extended the benefit. That's right. And
Okay,
appellate court,
okay,
nothing, lordship, not
okay.
a single line.
Okay. MS Bhattacharjee, learned counsel for the appellant, further submits that the learned trial court, though considered granting benefit of the provision of provisions of Offenders Act 1958, within bracket hereinafter referred to as the Act 1958. However, no reasons has been cited and proper considerations were not made for grant or rejection of benefit of such a beneficial legislation. According to the learned counsel, it is that the accused are having a right of consideration under the Act 1958, and therefore the right of the petitioner has been violated. According to her, the learned appellate court even did not invoke the provision of the Act of 1958 nor the provisions of Section 360 CRPC while sentencing the accused appellants. And the trial court has not given any special reason in the impugned judgment and order of conviction and sentence for not giving benefit of provisions of such provisions. Full stop. Mr. Chakraborty, learned counsel appearing for the victim, informant submits that it is an admitted position that both the petitioner, both the accused and the victim are neighbors, and they had some earlier there were some litigations between them earlier, and the issue of the fight was also very trivial in nature. Therefore, in his usual fairness, he submits that he will have no objection if the case of the petitioner is considered under probation of offender X by upholding the decision passed by the learned courts below. The learned additional public prosecutor, Mr. Sharma, has also fairly submits that the accused is having a valuable right for proper consideration of consideration under section under the Act 1958. However, the learned trial court has mechanically rejected such prayer only on the ground taking note of the nature of the offense. Full stop. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. This court, after perusal of the materials available on record, has also not found anything, any patent error or illegality in the illegality in passing the judgment. Therefore, without going to the merit of this court any further, this court will now deal with the entitlement of the petitioner of the benefit under Provisions of Offenders Act 1958. The Honorable Apex Court in Ratanlal versus State of Punjab, reported in AIR 1965 SC 444. Not necessary, I will not go to that. The Honorable Apex Court, in a recent judgment in Taraknath Kesri versus State of West Bengal, reported in 2023 SCC Online SC 605, after elaborately dealing with the provision of the Act 1958, 1958 laid certain propositions of law for exercise of power, full stop. According, the Honorable Apex Court held that the power of the court to release certain offenders on probation of good conduct when any person is found guilty of having committed an offense. No. Okay. Guilty of an offense not punishable with death or imprisonment of life, and where the court is of the opinion that the accused found guilty can be released on probation for good conduct and having due regard to the circumstances of the case, court can allow such benefit of such provision. It is by now well settled that the Probations of Offenders Act 1958 is a milestone in progress of modern liberal trend of reform in the field of penology. It is the doctrine, it is the result of the doctrine, it is the result of recognition of doctrine that the object of criminal law is more to reform the individual offender than to punish him. Full stop. It was also held by Honorable Apex Court in the case of Ved Prakash versus State of Haryana, reported in 1981, 1 SCC 447, that a court must give emphasis and that sentencing an accused person is a sensitive exercise of discretion and not a routine or mechanical prescription acting on hunch. Hunch. The trial court should collect material necessary to help award a just punishment in circumstances. It was further held that the social background and the personal factors of the crime doer are very relevant, although are very relevant in this regard. Okay, fine. In the case of Sitaram Paswan versus State of Bihar, reported in AIR 2005 SC 3534, the Honorable Apex Court has laid down certain principle for exercise of discretionary power under the Act and the considerations required. Full stop. The Honorable Apex Court opined that while exercising the discretionary power under the Act 1958, the court has to consider circumstances of the case, the nature of offense and the character of the offender. While considering the nature of the offense, the court must take a realistic view of the gravity of the offense, the impact which the offense had on the victim, the benefit available to the accused, it was concluded by the Honorable Apex Court that the benefit available to the accused under Section 4 of the Probation of Offenders Act is subject to the limitation embodied in the provisions, and the word may clearly indicates that the discretion vested with the court whether to release the offender in exercise of powers under Section 3 or 4 of the Act 1958, having regard to the nature of the offense, the character of the offender, and overall circumstances of the case. In this, it was further held by the Honorable Apex Court that such power can be exercised by the court even at the appellate or revisional stage, or also by Apex Court hearing appeal under Section 136 of the Constitution of India. Now, in the aforesaid, now in the backdrop of aforesaid settled principles of law, let this court consider the arguments advanced by the learned counsel for the parties. Full stop. In the case in hand, the incident, the offense was committed in the year
2009.
2009. The parties are admittedly neighbors. The nature of offense cannot also be said to be heinous in nature. In the given circumstances of this case, it is also on record that there were previous enmity before the lodging of the affair. First, it is also asserted by the learned counsel that the petitioner has not committed any similar nature of offense, or to say any offense prior to the incident or during pendency of this appeal till date. The learned counsel for the respondent has also submitted that his clients are not aware of any criminal activities on instruction submits any criminal activities of the petitioner. Therefore, Full stop. This court also have considered that the accused petitioner has suffered for last how many years? 2009 to
2024.
huh? Last 15 years litigating in the court and facing trial, appeal, and revision jurisdiction. Considering the above stated facts, without in entering into the judgment, merit of the judgment in mute, and considering the relevant provisions of law and settled proposition, and also the period lapse from the date of incident and also the evidence of PW1 and DW1 that there are certain altercation between them and between them.
Medical
No,
officer.
sorry,
PW2.
PW2 and DW1 that there were some altercations as regards a trivial issue of keeping what was that, cow or bull, something like that,
Cow.
uh,
Cow.
keeping a pet cow in the field, and it took place without any premeditation of mine. And that the punishment awarded for the offenses are maximum after appellate 1 year. 1 year. 1 year. This court is of the considered opinion that it fit case that it is a considered opinion that this is a fit case where the benefit of provision of the Act 1958 should be provided to the accused petitioners by this court in exercise of its revisional power. Accordingly, for the reasons recorded herein above, the appellant, namely
Ratul Mia.
Ratul Bhuya, it is Ratul Bhuya. The benefit under Provisions of Offenders Act is given and sentence is modified to that effect, and it is provided that instead of sending him to jail, they should be given benefit under Section 4 of the Probation of Offenders Act 1958. Accordingly, it is directed them to file 2 sureties, each to the tune of rupees 20,000, along with personal bond before the probation officer is there. It should be before the probation officer or before the court?
I think before the concerned court where, my lord, the admonition part also will be carried out, I suppose. Because in the Act of 1958 also the provision of admonition is there. So
What should be the order? Tell us.
before the court, I suppose.
Before the
Before the court of where the trial was
before the learned
Chief
Trial
Judicial
court.
Magistrate Golaghat.
that is Chief Judicial Magistrate Golaghat, and undertake to the effect that the petitioner shall maintain peace and good behavior during the period of 1 year from today. Said the aforesaid bond are to be filed by the petitioner within a period of 2 months from the date of this judgment.
Obliged.
With the aforesaid, the revision petition stands allowed. One gone. Then this is item number 8. Then 1. Rest is fine, same. Item number 1, which one is? I don't know. What are the offense here?
My lord, in this case, the 4 persons, they were convicted under section 447, 325, 34 IPC. By the learned additional CGM Nalbari, my lord.
What should be the punishment?
Punishment, my
It is
lord,
not like death and
447, my lord, only fine of rupees 500, my lord. Then in default, SI for 10 days.
Mm.
Then, my lord, under section 325 by 34 IPC, RI for 2 years.
Mm.
That is by trial court, my lord.
Mm.
2 years and a fine of rupees 1000 each in default of RI for 15 days. And
Mr.
both the-
Chaudhuri, so admittedly, these are the offense under which benefit can be granted. There is no doubt about that. And it has not been granted. So we are exercising power under revisional jurisdiction. So whether we can exercise the power, what should be the parameters we have already dictated, stated in the earlier judgment. Facts is we'll just dictate later on. Now tell us, arguments is more or less same.
Case, my lord, this appellants, my lord, in the appeal, criminal appeal, my lord.
Mm.
They are, my lord, acquitted of the charge under section 430, 447
Mm.
and my lord 325.
Mm.
They're sentenced under section 323 IPC
Okay,
and my lord directed to pay a fine of rupees 1000.
okay.
Only fine of 1000, my lord.
Only fine of 1000. Okay, now
And-
same. So this is a common judgment, only facts will have to,
Facts,
that is only the thing. And who will,
these two appellants.
Mm.
Originally, there were 4, my lord.
Mm.
Because as these two appellants, they were in government service, my lord.
Mm.
They have preferred this revision.
Mm.
Otherwise, my lord, they have already paid the fine also, my lord.
Okay.
All the 4 persons have paid their fines.
Okay, let us dictate this order. So, Mr. Chaudhuri, let me dictate this order. Anything is incorrect, please point me out.
Application they have also fined the records
Ah.
there. Amar record.
Anything whatever?
No one.
Heard Mr. B.M. Chaudhuri, learned counsel for the petitioner. Also heard Mr. Borthakur, learned counsel, additional public prosecutor. None appears for the respondent number 2. The present petition under section 401 read with section 397 of the Code of Criminal Procedure 1973 is preferred, assailing judgment and order dated 22/7/2011 passed by learned District and Session Judge Nalbari in Criminal Appeal number 6 of 2009, whereby there is no altercation in this case. There is no alteration by the appellate court.
Yes, madam.
There is altercation.
Yes.
So you just write it down. Just by this application, so and so, the petitioner assails the judgment and order dated 17/1/2009 passed by learned additional chief judicial magistrate Nalbari in CR case number 425C/2007, whereby the accused petitioners were convicted under section 447, 325/34 IPC and were sentenced to undergo
Just to pay a fine of
sentenced to pay fine of rupees 500 each for the offense under section 445 IPC and in default simple imprisonment for 10 days. Full stop. They were further sentenced to rigorous imprisonment for 2 years and to pay fine of rupees 1,000 1,000 and in default arrive for 15 days each under section
325/34 IPC.
under section 325/30/34 IPC. Aforesaid judgment and sentence was challenged by the petitioners in criminal appeal number 06/2009 before the learned session judge Nalbari in criminal appeal number 06/2009. The said appeal also met with the same fate, and the learned session judge. However, the learned session judge modified the judgment and order impugned therein by what is the final part?
Sentencing under section 323 IPC.
Whereby they were
Convicted under section.
and they were convicted under section 323 IPC and were sentenced to pay the aforesaid judgment is not fair, not the same fate, was modified, altered and modified, and the petitioner were sentenced to undergo were convicted under section 323 IPC and were sentenced to pay a fine of rupees 1,000 each and in default to
custody for
arrive
15
jail custody for 15 days. Full stop. Therefore, say judgment, two judgments are challenged before this court. Before this court. The prosecution story in nutshell is that on 7/6/2007 at about 8 AM, the complainant and her sister-in-law went to the paddy field to serve to her brother-in-laws and found the accused person
Four persons were there.
four accused persons had come there and surrounded the victim. Full stop. When the complainant and her sister tried to stop the accused person, they hit her with a what we'll call handle of a spade. Handle of a spade and threw her and he fell down. As a result, her left hand was injured.
Handle of an X, my lord.
Handle of an X. Okay. X. The accused person left full stop. According to the informant, the accused person also pushed the sister of the informant and tore her blouse. Accordingly, the complaint was filed before the learned Chief Judicial Magistrate Nalbari. The learned magistrate took cognizance of the offense. The accused appeared before the learned magistrate on receipt of summons. Full stop. Formal charges were framed under section 447/325/323/34 IPC, which accused pleads not guilty and claimed to be tried. During the course of trial, how many witnesses?
Four witnesses.
Four witnesses were examined. Four witnesses, including the informant, the doctor who examined the victim, two doctors, PW2 and PW3, and PW4 was the brother of the informant. Is that it? Who was in the field? Okay. No defense witness? Okay. The subsequently, the sentence, conviction and sentence as recorded herein was passed after completion of the trial. Okay. Then rest is same argument, same allowed. To the
Trial court only, my lord, the convert that has already come.
already come. Only trial court, appellate court has not considered. That set is the same.
Only thing, my lord, that they are government servant, my
Ah,
lord, I have. got one
Mr.
decision that they are sufficient.
Then, upper line to the Smita ji to Likhi, I'll correct it. Then, also consider that they are government servants and in the mean, they were government servants. They had already been retired and retired. Full stop. That's all. To appear
They
before.
are not right, my lord, that retired, my lord, because
Okay,
their age
okay.
is not.
They were government servant at the relevant point. They were government servant. That's much. We'll consider this. And now tell us before whom they will appear. To
They
is-
have
if the
already paid the, my lord, fine,
Then,
only
but,
for the probation, my lord, they have
probation-
to appear before the trial court. my
trial
lord.
court appear before
Then
the trial court.
will pass an order,
Pass
that
an
they will
order.
be on probation for
Okay,
so and so period, my lord.
okay. That's all. Dispose of.
This was. Obliged, Lordship.
Keep this judgment also. This tree, but Mr. Chaudhuri, you will get all this order around Tuesday or Wednesday. I may not be available here and all correction and all so many disposals are there.
My lord.
It's difficult because every line is to be seen.
Obliged, Lordship.
Yes, 5. What was the offense?
84, your lordship.
Huh? What it says 384.
Extortion, your lord.
Huh?
Extortion.
What is the maximum punishment?
Extend to 3 years, which may extend to 3 years, your lordship.
Extended to 3 years.
Yes.
Now, what is to be done here?
Fine.
It was not considered.
No.
Straight away given.
My lord,
Same principle will be applicable.
my lord, here, my argument will be on one point only, my lord. There is a specific provision under 372, my lord. It will not come under the 482 application, my lord.
This question, maintainability of this share.
My lord, just I engaged by the state legal service.
No, that we understand. You are saying that this criminal petition is not maintainable.
My lord, there is a provision under 372.
Is it your argument?
My lord.
So therefore, why? There is a special provision of
My lord, 372 said that if any lesser amount or that lesser that's compensation, my lord, then that can be come under the 372, my lord.
let us see. Share PC. How many matters are there?
482.
Good, no? Nothing good. 9 to be actually.
372 said that no appeal to lie unless otherwise provided.
372.
370.
When this offense was committed and when it was filed
Offense was committed on 8, your lordship.
and when it was filed before this court.
Before this court, your lordship. 2012, your lordship.
2012.
7.
So these are basically inadequate compensation and against acquittal and lesser punishment. So
Even-
this is a consideration that a special statute is there. There is no that has not been considered.
Right.
Or if it is considered, it is
No
uh,
proper ground,
erroneously
no proper
considered.
ground has the
That is,
express, my lord.
now what will you say on that?
My lord, that part, my lord, my.
What was the,
prefer-
what was the three kidnapping?
Extortion, my lord. He has demanded some money like that in the name
And
of
it was established.
BPL like that.
Now suppose we hold that it is, we have already held that it will have to apply its mind. In other cases, it will have to apply, it cannot be a routine manner. It's a very important facet of criminal jurisprudence. Now it will have to see the impact on the victim also, that we have already recorded in the principle of law. Now suppose you are opposing, victim has come.
Victim is.
Victim has come, victim is aggrieved, so definitely will give a hearing to them. Now suppose we hold that this is not correct, then what is to be done?
Otherwise, my lord, it is that sentence was, punishment was given 2012. By presuming that is my good conduct for a particular year,
That
my
is,
lord.
let that be considered by the learned trial court.
Because my lord, from 2012, my lord,
Maybe, but we cannot think you file material saying that I am keeping in good. So they will consider in laid down in principle of law. That can be one aspect. Otherwise, we'll have to see whether at this stage we'll exercise our power.
that's my lord, under.
Enlighten us what is to be done. According to you, what should be done?
Remanded back to the.
No, I am saying something, you are saying remand. Why should I remand it back? Give us some reasons, logics.
Here in the lordship, 361 is special. Your lordship, special reason has to be recorded in certain cases when the court deal with the, like provision 360 or provision of
Okay, list this matter. I'll have to come prepared. You people are not prepared. List this matter for hearing once again on. Give me that short date next week. It will not take much time. 21st.
Master.
Under 279 matter of the CRPC of the motor accident case.
What is the, how many,
My lord,
what is the period?
your is my.
Three offenses, 279, 338, 304A. One person died in the spot.
My lord, about 6 months.
6 months.
Fine. 338 2 month and another is for
6 months.
6 months.
What is your argument?
And 6 months.
Very simple, my lord. It's a fact, my lord, that was an accident was there. It's that the bike was led by a young boy, my lord, met it in 13 years back, my lord. And but the injury was not as grievous as that, my lord. It is just from the backside, he hit it. The old man, 62 years, fell down and he died because the postmortem report shows that there's no external injury there. So my priority, my lord, Section 4 of the Prohibition Act may be imposed, my lord, and the fine which is there, my lord, or because it is imprisonment with fine. It is not that intention or something, my lord.
But from the record itself reveals, my lord, all the eyewitnesses, all of them, my lord,
That's
in
it.
so recent
That-
negligence, my lord.
yes, so, but here, look,
He-
you go to the postmortem report, if my learned friend says so. I'm just,
I have seen already seen.
there's no external injury.
It
I
was
think
caused
very
as a
fast.
result of hemorrhage and shock.
So, that is.
That is different,
Internal injury.
my lord.
He fell down,
And
so,
That's. that is-
and there is a head injury.
my lord.
Otherwise,
Both wife and husband are
Actually,
running,
what happened
my
when
lord,
my lord-
walking.
When the motorcycle was coming, the wife was on the left side. He tried to cross the road and he missed it. So I pray my lord, Section 4 of the Prohibition Act may be imposed.
PW1 is the eyewitness, my lord, in
Yes,
this
sir.
case, my lord.
this
Yes,
is the
it-
benefit of getting this, all this admitted and taking up for hearing after 10 years. Nowadays, this will not happen. We will decide in the admission stage itself.
Yes.
Because you get an additional benefit that
Right.
this matter is pending since so and so.
Mm.
My age was so and
Yes,
so.
sir.
Now I have become so. Yes, we'll take up it in some other day. Just take note of the judgment 2012 2 SCC 182. And you address us on that.
2000.
2012 2 SCC 182, which says punishment, Supreme Court judgment,
Navajit Singh. Whose case?
Balbinder Singh.
Balbinder Singh. Sorry.
Ah.
I thought.
It says the punishment for causing death by rash or negligent driving should be deterrent in view of frequency of such incident. Now you have seen we are already there are frequencies has increased.
My lord, but here is the point is here, my lord. It is not a rash and negligent driving, my lord.
No, that already held rash and to
Both
be
the
rash
court
and-
already
then
held.
we'll have to enter into the merit.
So then that.
Then we'll have to enter into the
No,
merit.
because the postmortem report doesn't say so.
No, that is merit. We'll have to enter merit. If you want to argue on merit, that is it.
Go for, because the accident has occurred that I concede, but not in the. That is why I say section 4, man, because this man is already 10 years, about 50, 55 years. And if he goes to the jail, my lord, yes, he will be also in the doldrum.
Now you take note of 1999 5 SCC 732. Then 2010 12 SCC 26.
2012,
2010 12 SCC 26. Both of you just go through.
Lordship 1995 5 SCC
1999
99 5.
5 SCC 732.
32.
Now anything was considered in under the 306 or Provender Province of Offence Act by the trial court?
no, man, they are not.
No consideration. That can be one ground. By the appellate court,
No.
No
State way
consi-
upheld that one.
there is no discussion that whether it should be granted or not. Okay, that can be another ground. Then you look into the judgment. Huh. 2001 10 SCC 477. Just go through this judgment. And there are two issues. It is ultimately a date.
My lord, that is
Because in all judgment, it says that it should be the statutory prescription is exception is death and life
my lord, that
imprisonment.
is
But principle evolved by judicial pronouncement says that we'll have to look into the nature and gravity.
gravity.
So this is one aspect. Other aspect is that there is no doubt that we can exercise his power. Third issue is that when the learned trial judge and appellate court has not considered whether that will vitiate the entire conviction. That is another aspect. When we fix the other matter,
25 no?
21st, list this matter again on 21st of December.
I will approve.
Yes, Mr. Rajgupta.
This case with the petitioner is a railway employee, my lord. He is of 58 years of age. And so far the wife, his wife is concerned, my lord. She also got married.
Hmm.
There was a maintenance case.
Hmm.
And that maintenance case was settled outside the court.
Hmm.
I have checked all these documents. However, one thing that I have noticed, that he gave talak to his wife,
Hmm.
but so far this Mohana amount is concerned, that is rupees 1,01,000. That amount has not been paid till date.
Now ask him whether he wants to go inside or want to settle it.
No, definitely, I am very able to settle it.
Ask him whether he at
No,
this.
I asked him, today morning he also came to my.
What is what he says?
No, he will pay this rupees 1,01,000 to his wife, the Mohana amount.
Hmm. Where do you get anything on that? Wife is before us.
No, that
Yes.
is the problem.
She has got married.
She got married and she also admitted that thing.
What is the total period of offense?
1 year.
Huh?
1 year.
1 year.
1 year.
Now, where is that your wife's statement that she got married in the meantime?
Yes. That I can.
I have gone through the point you have raised will not help you. That non-examination of IO. I applied my mind. Because see, that was very nicely dealt by the appellate court.
Yes.
And I have also gone through your PW, that lady's person. Only contradiction was made certain point. Assuming for a moment that is minus. Otherwise, there are specific that she has remained unshaken when demanded, how it was given, cruelty, everything is there. So therefore, if you have settled, we can again give it a probation of offenders. Then at least you will not go to jail. It will remain as it is. Your job will be saved. But that will do provided you file an affidavit saying that we have already settled. Of course, we can exercise our inherent part. We have already settled. Her statement, deposition already clarifies that she got married, and her amount of so and so I have already deposited.
I had not. I will deposit this.
I will deposit. That's why I'm not saying today. You deposit it and give a proof with an affidavit. Will exercise our power.
The registry itself.
Not registry. You give a transfer.
Paragraph 9.
Transfer her to her account.
I have to call it. Paragraph 9.
So therefore, we are paragraph 9.
This matter can be settled.
That is why. Otherwise, it will be difficult on your part. This is statement where
Before the court of magistrate, when she filed an application under section 127
so
for
you bring,
enhancement of maintenance allowance.
bring
And
on-
ultimately, this matter was settled.
so you bring on that both of the documents will exercise your 482 power. You bring this in a document by way of an affidavit. You bring that document by way of an affidavit. Then you give the
Even
proof
undertaking that I will pay this amount.
and bring a proof of document that you have already transferred the amount to her
No, I
account.
have not transferred.
No, that on the next date, you in the meantime transfer it to her.
I can transfer it if she agrees to take it, but she made a separate.
No, whatsoever. There was a compromise. You are supposed to pay the mohar. You pay it. You pay it through her bank account, collect it, and come back to us with an affidavit. We'll allow your things. Your job will be saved.
That will be the one thing, best thing I think.
That otherwise in revisional court, I applied my mind. It will be difficult subject to
Also, I have also checked up.
subject to what you argue. There are many judgments where it says
I
that.
want to settle this matter.
In fact, we will not like to if they are settled in a different way. But you have to give us a handle.
It's definitely.
Otherwise, we cannot.
Your Lordship made some observation. I will.
Okay.
comply with it.
Heard Mr. Dasgupta, learned senior counsel, assisted by B. Das. Basabi Das. The present petition under present revision petition under section 482 CRPC is filed assailing a judgment and order dated 1/11/2011 passed by the learned judicial magistrate first class, Rongia in GR case number 112/08 convicting the accused under section 498A IPC and sentencing him to undergo simple imprisonment for 1 year and pay fine of rupees 5,000. Full stop. 5,000 and in default a further imprisonment of 3 months. The further challenge is a judgment and order dated 19/6/2013 passed by the learned additional session judge within bracket FTC, Kamrup Rongia in criminal appeal number 76/2011, whereby the judgment dated 1/11/2011 passed by the judicial magistrate first class was upheld. Full stop. Upheld. Mr. Dasgupta Learned Counsel submits that the petitioner is petitioner is a central government employee currently serving in the India Railways, and he is in the fag end of his career.
58 years.
And presently he is at 58 of years. Full stop. 58 of years. Full stop. It is further submitted by Mr. Dasgupta that the dispute have amicably settled between the parties in FC criminal case number 273/2011, which was filed by the petitioner seeking divorce, is not it?
Yes.
Seeking divorce. Full
No.
stop. It was filed.
Maintenance.
Which was filed by the respondent wife seeking maintenance. Full stop. It is also submitted that they have already got divorced by way of their personal law in adherence of following the procedure of their personal law. It is further submitted by Mr. Dasgupta that what is
Parties got married.
that both part after divorce got married to different persons, and they are living their happy family life, and only thing remains is the payment of dawar, DWAR, maher, MHAR, maher of amounting to rupees 1. Amounting
1,000 something like
amounting to rupees 1,01,000. 1,01,000 required to be paid during that period. First up, Mr. Dasgupta further submits that the petitioner is willing to pay the said amount, and therefore this court should exercise power under section 482 CRPC to allow the petitioner to go on probation, allow the petitioner to entail the benefit of section 4 of the Swenso Act 1958. Probation of Offenders Act 1958, read with section 360 and 361 CRPC. Full stop. Accordingly, he submits that he may be granted 2 weeks time to 2 weeks time to bring on record the aforesaid facts which has occurred during the pendency of the present case. Full stop. Prayer is
kindly fix a date.
Prayer is allowed. List this matter on. After 2 weeks. Fifth of December 2024. You just bring all these papers
That will file an affidavit.
and by way of an affidavit saying that this is the situation, now I have paid this. That's all. And also make 2-3 statements that you have never been involved in any cases. These and all will consider it. That is the only way out.
Only way on.
No
I
other.
have checked up throughout the day.
Huh?
Yesterday.
I spend my morning in your case only. What to?
No, I spent yesterday the whole day.
Difficult. I have taken out many judgments. No way. That
No, I have
and IOS is not at all fatal. It will be fatal when it prejudices you. There is no.
Because one section 145, the Evidence Act was not strictly complied.
Not complied with. And nowadays,
First
Supreme Court.
First part was complied with,
Second
second
part
part
was not complied.
It was, she was not confronted.
Not
with.
confronted.
Right?
Even
That's
not quote unquote.
what I'm doing.
If it is not even confronted, we may consider if it is quote unquote that you have stated this. That is also not there. And whatever is given, that is not relevant for determination. Only one sentence.
153 was also. Will be the better.
Better.
I am much of that.
Yes, next case. Yes, Mr. Bothakur, what to do? I think list should be.
Yes.
They thought that the hearing matters, it takes time. I have written it. These are two judgments. These are very important. Huh? It is not important. But the other time, it don't have.